So Judge Lopez and I wanted to discuss a little bit about the quick approach setting on the online scheduling system and how to utilize it and why to utilize it. Judge Lopez, why would somebody need to use the quick approach?
I'll start by share screening. That way everybody can see where it's located. So this is the online scheduling system for the 308th. If you go down to the second portion where it says uncontested, you'll see the last option, which is the fourth option within that section, are quick approaches or a quick approach. And this setting requires all attorneys and parties of record to approach the judge to discuss any issue that cannot be addressed otherwise or by submission. So when can an attorney or parties use a quick approach? I think the best example would be you just need to approach the court really quickly and everybody agrees. I cannot emphasize that enough. Everyone agrees and everybody is available and wants to approach the court. This would be parallel or equivalent to back in the day. I can't believe I'm saying back in the day. When you would just go into the courthouse, ask the clerk or the coordinator if the judge was available to approach the court and to talk to the judge. It's the same thing, but unfortunately with our current pandemic or current times, it'll be done virtually. So again, I emphasize all parties, all lawyers have to agree and they have to be available. So my suggestion to you is when you schedule a quick approach, which is just 10 minutes, 10, 15 minutes to discuss whatever the parties wish to address with the court, make it known to the court that everybody agrees. Everybody is available on February 2nd, 2022 at 4 p.m. for 10 minutes, Judge, and everybody is going to be there. That way, I know there's no issue as to 3 days notice, 21A. We're not going to discuss a motion that hasn't been properly served on everybody or noticed as to a specific time to approach. Can you think of any other times that we can use or that the attorneys and parties can use a quick approach, Judge Lapidi?
I usually tell people to schedule a quick approach if you have an adoption and I have already given you a trial date after, or a special immigrant juvenile status case. I've given you a trial date after our pretrial and something has transpired between the pretrial date and the trial date. I always say schedule an approach with me so that way I can give you a new trial date. So when you show up on the actual trial date, or we can, so nobody shows up on the actual trial date and we have to reset it.
I've also had my court coordinator suggest to parties to schedule a quick approach when there's something that the parties, whether it be your client or yourself, do not wish to place in a motion. It could be very personal. There's a health issue, there's a family issue, but the court needs to know that something is transpiring, whether it's personally an attorney has to obtain a reset and doesn't necessarily want to make that public record in the case file. So if everybody just agrees to approach, it could be quickly done. It could be done very quickly and the attorney can be very candid and honest with the court, and we would appreciate it and honor and respect that privacy. And then we can move on. That way you don't have to sit on pins and needles until trial date to announce on a public docket with 60 cases that you need a reset for a personal reason, right? So that's a good alternative if not everybody can draft an agreed order for continuance and it's easier for everybody to just log on quickly.
So let's talk about when not to utilize the quick approach.
Okay, quick approach is not a form to approach the court to tell us why a motion should have been granted instead of denied. A better alternative would be a motion to reconsider, right? It may be that certainly, yes, I, as a judge, got it wrong and should reconsider a motion or a rendition I've made on the submission docket. But quickly approaching or scheduling a quick approach without all the parties present is not a way to use the quick approach.
Additionally, please do not schedule a quick approach because you have an entry date coming up and you want a new entry setting. If you need a new entry setting, please file a motion for continuance on that entry. Please do not schedule a quick approach with me or Judge Lopez.
Do not schedule a quick approach if you need to address a specific setting that needs to be reset. And that goes not only for entries, but like a hearing for temporary orders. Again, it may be that you do schedule on the quick approach if everybody's available, but the key point is that everybody has to be available. Similar again to being in court, you can approach a conduct ex parte without unnecessary parties present. So it's not a method of scheduling to go against all of the other dockets we have. I've also seen people try to schedule uncontested prove-ups, whether they be English or Spanish, on quick approach, and that's not the way to do it. We have an uncontested docket specifically designated for that, and under quick approach is used and utilized for a different reason. I think that covers quick approach. The key point I want everybody to get out of it is all parties must be present, whether they're represented through an attorney on that approach or through a pro se litigant. Everybody must be present, and it is an alternative to what we used to do, just approach a court in person. I can appreciate that through technology and through these times, there's a feeling or a loss of availability, or a feeling that the court may not be as available or open as pre-pandemic. And this is an alternative and something that the 308 is providing all parties and attorneys. We want to make sure that your questions are answered, that your concerns are heard, and you feel that you can approach quickly to provide a solution to something that is happening, whether it be personally or in the case.